Judgment in the appeal, Mitsui Co Ltd.
Lord Hodge will give the judgment to the court.
Piracy has an ancient history. So too has the law of general average. This case concerns modern piracy off the coast of Somalia in East Africa. On 29th January 2009, the chemical carrier MV Longchamp, which was owned by the Appellants Mitsui, which is owned by the Appellants Mitsui, was seized by pirates in the Gulf of Aden. The pirates demanded a ransom of $6 million United States dollars. The owners set up a crisis management team which, after 7 weeks of negotiation, agreed with the pirates a ransom of $1.85 million. When the ransom was paid, the pirates released the vessel and its crew. The law of general average is a set of rules of maritime law which is thought to date back to the law of the Rhodians in ancient times, from where it was adopted by the Romans. Historically, business ventures by sea involved many perils, which the owners of the ship and the owners of its cargo had to face. General average involves the sharing of those risks, more specifically, property which is sacrificed, such as cargo thrown overboard, or loss or expenditure incurred as a direct result of actions taken to preserve the common maritime adventure. That's the vessel and the rest of the cargo, from peril, are shared ratably between all of those whose property was at risk. The modern rules of general average are set out in the York-Antwerp Rules, an internationally agreed set of rules. The appellant vessel owners and the respondents, who were the cargo owners, adopted a version of these rules in their contract, which was a bill of lading. The essential question in the appeal was whether the expenses of operating the vessel, such as the fuel consumed and the crew's wages, which the owners incurred in the 7 weeks of negotiation when the vessel was in the hands of the pirates, fell within the rules of general average under Rule F of the York-Antwerp Rules, which provides, and I quote, "Any extra expense incurred in place of another expense, which would have been allowable as general average, shall be deemed to be general average and so allowed without regard to the saving, if any, to other interests, but only up to the amount of the general average expense avoided." The owners argued that this rule, Rule F, applied because the operating costs incurred in the negotiation period were extra expense incurred in place of the expense, which amounted to $4.15 million US dollars, which would have been incurred if they had paid the full ransom. The owners succeeded before an adjudicator and in the High Court, but the Court of Appeal reversed the ruling and held that the owners could not recover the vessel operating expenses during the period of negotiation. This court, by majority, allows the owners' appeal. Lord Neuberger writes the leading judgment, and Lord Sumption produces a short concurring judgment. Lord Mance dissents not on the law, but on its application to the facts proved in the evidence. In summary, the majority held that Rule F did not require the owners to show that it was reasonable to have paid the ransom of $6 million. The reference in the rule to another expense which would have been allowable as general average, for which the Rule F expenditure is a substitute, is properly understood to be a reference to the nature or type of expense and not its quantification. Otherwise, payment incurred to avoid paying a reasonable sum would fall within Rule F, while payment to avoid paying an unreasonable sum, or costs incurred to avoid paying an unreasonable sum, would not. Secondly, the negotiation period expenses were an alternative course of action incurred in place of paying the $4.15 million, which the owners otherwise might have paid. There was, in any event, no justification to read into Rule F, which is a provision in an international arrangement, a requirement that there be an alternative course of action. Thirdly, it was not necessary for the owners to demonstrate that they consciously chose to incur the negotiation period expenses in order to reduce the ransom payable. The question whether one expense has been incurred in the words of Rule F, in place of another expense, must be assessed objectively. Fourthly, it was not correct to interpret the word extra in Rule F in a restrictive way to mean that the expense had to be of a nature which would not normally be incurred in response to a peril threatening the adventure. Fifthly, it was not correct that because the negotiation period expenses fell outside the other rules, namely Rule C and Rule 9, they could not fall within Rule F. By definition, sums recoverable under Rule F are not otherwise recoverable as general average, but are alternatives to the sums which would be so allowable. Lord Sumption, in his concurring judgment, observes that while the Supreme Court's interpretation departs from the practice of many or most loss adjusters, such practices are not law. The law is contained in the concepts expressed in the rules themselves.
The court will adjourn.